Hello, everyone. My name is Chris Sweeney. I am the Workforce Development Project Coordinator here at Maryland Volunteer Lawyer Service. Thanks for watching today. I'm going to be going over some information about criminal record expungement. We have done a number of trainings on how to do criminal record expungements. This webinar is going to be more of a short history of developments in expungement law over the last several years, and then a discussion of some of the lingering problems that still exist with expungement law in Maryland and the negative outcomes for people living with a criminal record that are not being addressed despite the increase in eligibility and availability of expungement over the last several years. So it's a relatively recent development in Maryland's legal landscape that criminal record expungement is widely available to people. There was a time when expungement was close to impossible to access. There was a point in time where a conviction at any time on a person's record would block all other criminal cases from coming off their record. That would go for cases that were completely dropped, dismissed, or even where the person was acquitted. Around 2015, non-convictions became eligible for expungement. So cases where all of the charges received a null pros, acquittal, dismissal, stet, probation before judgment, the criminal procedure 10-105 that many expungement practitioners would be familiar with that codified these non-convictions becoming eligible for expungement. And this really started a pretty massive wave of expungement filings in the courts. It became a huge issue for legal services organizations and community advocacy organizations to get as many expungements filed as possible, with the quite large increase in the availability of the expungement process. It also started a conversation about the important impact that expungement can have on a person's life. Someone who has been arrested, been charged with the crime, or been convicted and served their time, and how those lingering effects can continue to have negative consequences on a person's life even after they have allegedly paid their debt to the state for the crimes that they were convicted of. And then a few years later, there were some limited convictions added to the list of eligible cases. So that was primarily added into criminal procedure 10-110, as well as some changes to criminal procedure 10-105. So things like marijuana possession conviction, and then of course in 10-110 of the criminal procedure article, you had the enumerated list of eligible crimes where a person being convicted of one of those and meeting all of the other eligibility requirements for expungement had the potential to expunge a conviction. And then there were actually even felonies added to that list as well. So a relatively small list of felonies, mostly related to drug possession, and a slightly larger list of misdemeanors that single out a number of basically nonviolent offenses and not particularly egregious offenses that, if convicted, a person has the opportunity to expunge potentially. And we're going to talk a lot about the waiting periods and other prerequisites that actually make it still quite difficult to expunge, especially convictions. So a lot of convictions on their face still remain completely ineligible. And we are going to talk a little bit about some examples of maybe some contradictory eligibility requirements where certain crimes are eligible and certain very similar or even arguably less severe crimes are left omitted from the list of eligibility. So in summary, there is a lot of improvement that has happened in the last 5, 6, 7 years in the area of criminal record expungement, and a lot of conversation has been happening about the importance of second chances and opportunities to expunge a record. However, as it stands, there is actually quite a bit of room for improvement in Maryland's expungement laws. So to talk a little bit about the consequences of living with a criminal record, just to emphasize the importance of why expungement can stand to be expanded even further. There are, of course, the familiar collateral consequences of more difficulty in accessing employment. That is the number one issue that gets talked about by advocates for expungement. Of course, the catch-22 that people are placed in, where they cannot get a job because of their criminal record, and of course, not being employed leads people to desperate financial situations and all sorts of pressure to potentially even go back into recidivism and end up with more crimes on their record. There is, of course, the housing issue as well, which is very similar to the employment issue. Someone released from prison and wanting to seek stability in their life, wanting to have stable employment, wanting to have a roof over their head, and being denied rental housing because of a criminal record. And then there are all sorts of other effects on someone's life, such as difficulty accessing childcare, difficulty in child custody proceedings, difficulty in participating in your child's life through attending field trips and all sorts of other things like that. And then there's the consequences of the waiting periods. I'm going to get into more detail about the specifics of how those work, but for the vast majority of potentially eligible convictions, you are looking at a 10 to 15 year waiting period, which begins after the completion of any sentence, including probation, parole, or supervision, which is often going to be even more than 10 or 15 years after the actual incident and conviction occurs. So if you can imagine waiting 15 years to be able to seek stable employment, just trying to imagine what someone could possibly do for 15 entire years to sustain themselves financially in that situation. And then there's also the social and psychological impact of living with the stigma of a criminal record. There is, in fact, research to indicate negative psychological impact on a person who has experienced negative stigma in their social circles, in employment, in seeking any other sorts of opportunities like that. So these are sort of, in the minds of many advocates, almost additional punishments that are being leveled against someone who has already completed their criminal sentence that was ordered by a court. And now they face an array of additional consequences that directly result from legal policies that are in place. So they are, in a sense, a second sentence or an additional level of punishment. To understand where we are at right now with Maryland criminal record expungement, let's talk a little bit about how expungement currently works. So I alluded before to the conviction and non-conviction sort of dichotomy that exists in expungement. There are a number of cases that are, of course, eligible for expungement. There are, in fact, probably thousands and thousands of cases on the books right now in Maryland that are eligible for expungement immediately, if not very soon, because if a person was not convicted of any of the charges in their case, then quite often they can expunge the case immediately. In some cases, there are 3-year waiting periods if there is a stet or a probation before judgment. Then talking about convictions, as I said, the vast majority of offenses are a 10 to 15-year waiting period if a person was found guilty of one or more of the charges against them. There is also the complicating factor of the subsequent conviction rule. So if someone is convicted of one crime that is potentially eligible according to the statute, and then a few years later, they are convicted of a separate crime in a totally separate incident, that second crime, that subsequent conviction, is going to do one of two things. It is going to either restart the waiting period for expungement if the subsequent conviction is itself an eligible type of case. It will essentially restart that clock and hold the previous case sort of hostage until the more recent case can be expunged, and then the person can expunge both of them. Or if the subsequent conviction is ineligible on its face, such as it's a violent crime or it's something that is simply ineligible because it was omitted, which does not necessarily mean it was a violent or egregious offense. It just means it happens to be omitted for whatever reason. Then that subsequent conviction is going to permanently block the older conviction from ever being expunged. And this is a blanket rule. It doesn't matter how minor the initial offense was. It doesn't matter really how long ago the initial offense was, so long as the subsequent conviction falls within that 3 to 10 to 15-year waiting period. And again, the list of the types of convictions that are allowed to be expunged is somewhat limited. There are many types of offenses that would logically, reasonably make sense to be included in the list when comparing what's already on there. However, many things are absent. So I will get into that in the coming slides. So getting into some of the things that are omitted from the current law. And again, we're primarily talking about problems that exist with the expungement of convictions. Expunging non-convictions is relatively simple. So one of the major glaring problems with what's ineligible for expungement for convictions is the absence of many traffic offenses. Until very, very recently, there were absolutely no traffic offenses listed in the eligibility statute. And to clarify when I'm talking about traffic offenses, the Maryland expungement laws divide traffic citations or traffic crimes into basically incarcerable and non-incarcerable offenses, meaning if the criminal statutes in Maryland allow for the possibility of incarceration as a punishment for a traffic offense, then that traffic offense is treated like any other crime for purposes of expungement. So something like speeding or unsafe lane change, those would be considered minor traffic offenses. A person cannot be incarcerated for those offenses. Therefore, they are a separate, totally separate from the expungement conversation. But something like driving without a license, which is an incarcerable offense, counts toward expungement as far as it is treated like any other crime when analyzing expungement eligibility. However, it is conspicuously absent from the expungement eligibility statute. And I will get into that specifically with an example in just a bit. To talk about some of the other somewhat incongruous omissions and inclusions in the statute, the crime of malicious burning of property is an eligible for expungement conviction. However, malicious destruction of property is omitted from the statute. I can say anecdotally from working with many expungement clients that malicious destruction of property is, in my experience, significantly more common to see on a record. I personally don't think I've ever seen malicious burning of property on someone's record. You can go back and forth about analyzing the actual text of those criminal statutes and which one sounds more severe, but it is something that many advocates have pointed out as being just a little bit strange that one thing was included and a similar thing was not included. There's also the issue of overcharging. There are many commonly charged offenses that many legal advocates and community advocates have seen on clients' records, particularly clients living in Baltimore City. Many people believe that there is a phenomenon of overcharging. In other words, the police adding certain types of charges onto a person's arrest after an arrest incident occurs. Very commonly, we see things like unauthorized motor vehicle use, and extremely commonly, we see resisting arrest. These are charges that, if convicted, cannot be expunged. The entire case cannot be expunged. And I will also say, from my personal experience, of course, anecdotally again, I have seen hundreds of clients who have an array of misdemeanor charges leveled against them in a particular case. Things like drug possession, theft, disorderly conduct, and resisting arrest is added on there as well. And in many cases, resisting arrest is the only charge that ends up sticking. So there are quite a few people who do believe that this is somewhat of a tactic that's being used to get people convicted of something if the charges aren't going to stick. And of course, that particular charge of resisting arrest is the one out of all of those that cannot be expunged. So now someone has been placed with having a permanent criminal record for life. And In many cases, a background report would also pull the other charges that the person was not even convicted of. So if a person is going to apply for a job and they pull a third-party background report, or they request a fingerprint report, the person's going to come up with having been charged with a whole bunch of stuff, 5 or 6 charges. None of them ended up with a conviction other than resisting arrest. And now that person has a permanent criminal record for life that they are dealing with, again, dealing with the stigma of that, the social consequences, the employment and financial consequences of that. And then to talk about the way the waiting periods work, when I was talking about the subsequent conviction rule, it may have been apparent, if you were working through in your mind how that would play out. If someone has, say, a misdemeanor theft on their record, say that's something as simple as shoplifting from a Royal Farms, some snacks or something like that, or a Gatorade or something. If someone is convicted of that, they are now facing 10 years of having to live with a criminal record. If this person, say, was denied employment a few years later because of the criminal record, and they had no money for food and they resorted to that behavior again out of desperation, say that happened even 9 years later, now they have another misdemeanor theft on their case. So now they're looking at a total of around 20 years of living with a criminal conviction on their record that's ineligible for expungement. And these can quickly stack up to 30, 40-year waiting periods. If someone is going through a period of turmoil in their life, if someone is going through homelessness or substance abuse, and they have a sort of cluster of criminal convictions on their record over the span of a few years, let's say they turned their life around, they seek help, they are ready to move on from that period of their life, they may be living with 15, 20, 30 years of having a criminal record and facing immense barriers to actually finding sustainable employment and housing. So to give a more concrete example of the sort of unusual outcomes that result from the way the current law works, let's say someone is convicted of first-degree burglary in 1995. This is a felony that has a 15-year waiting period to expunge. So let's say they serve their time, they are out in the world again 10 years later. In 2005, they commit first-degree burglary again and are convicted. Under the current law, there is the subsequent conviction rule blocking the 95 case until the 2005 case becomes eligible. Let's just say, for the simplicity of the example, that this person doesn't serve very much time for the 2005 offense and has to wait 15 years from 2005 to expunge. So they could expunge both cases in the year 2020. Now, let's say a different person is convicted in the same year, 1995, of first-degree burglary. Again, a felony with a 15-year waiting period. Then let's say in 2009, they are almost ready to pass that 15-year waiting period, and they are convicted of driving without a license. Driving without a license, as I mentioned earlier, is not eligible for expungement at all. So that permanently blocks the 1995 case from ever being expunged. So now someone who committed 2 felonies is allowed to have their record expunged in both cases as someone who committed one felony and then 14 years later committed a relatively minor misdemeanor offense, which does not endanger anyone's life or have really any negative consequences on any other person and no victim, now has a permanent criminal record for the rest of their life under the way the expungement laws in Maryland currently operate. So there have been a lot of discussions among advocates about what to do to address these somewhat absurd outcomes in the way the expungement laws work. One of the major things to do that has been proposed would be to reduce the waiting periods. In fact, Maryland has some of the longest waiting periods for criminal record expungement in the entire country. We are somewhere in the bottom 3 as far as the longest waiting periods of any state that allows expungement. Many states around the country, in fact, allow a person to expunge a misdemeanor immediately upon completion of the sentence. So one thing that has been proposed would be to reduce the waiting periods for misdemeanors from 10 years down to 3 years, and for most felonies to be reduced from 15 years down to 5 years. Now, again, if that reduction in years sounds dramatic, keep in mind that these waiting periods begin when the sentence is completed. So if someone commits a felony and they serve 10 years in prison, or they serve 5 years and then they serve 3 or 5 years probation or supervision after the fact, that's the time that they've served. That is the criminal punishment that has been meted out by our criminal justice system. That is the fair punishment that a court has decided fits the crime, and the person has completed it. So now the expungement waiting period is talking about simply allowing that person to remove it from their record after a certain period of essentially remaining free from convictions for that waiting period. Now, there would be exceptions to the 5-year waiting period for felonies if there were particularly egregious acts that were felt to be deserving of maybe longer waiting periods. There's also discussion of the expansion of eligibility. So the examples I gave of some of the traffic crimes and the malicious destruction of property being omitted from the eligibility, those are just a small handful of examples. There are many, many nonviolent misdemeanors that are simply ineligible. And like the resisting arrest, for another example, one of the major propositions among advocates is to essentially flip-flop the way the expungement eligibility for at least misdemeanor convictions works. So kind of create a photo negative of the current statutory scheme. In other words, instead of having an enumerated list that singles out specific misdemeanors as being eligible for expungement, having the statute say all misdemeanors are eligible after 3 years, and then if there need be exceptions, the exceptions to that rule can be the ones enumerated. That would eliminate the problem of having relatively minor convictions be ineligible. And this has really, to dive a little deeper into the problems that this creates for people's lives, the interpretation of what's eligible for expungement has created a host of problems in the courts. For example, certain laws criminalizing the consumption of alcohol in public. There are many local laws. There are many specific statutes that criminalize and kind of compartmentalize different ways that someone might consume alcohol, such as there's a separate crime for consuming alcohol in a retail establishment. There's a separate crime for possessing open container versus consuming the actual alcohol. I believe it was open container possession was added to the list of misdemeanors. However, someone convicted of a, like, for example, county level equivalent of open container that happened to be worded differently on their books in that particular county, myself and many other lawyers who practice lots of expungements actually saw judges deny the expungement for that open container because the crime the person was convicted of said something like consumption of alcohol in public. And because what was listed in the expungement statute was merely possessing the open container and didn't specify that the person actually had the beverage enter their mouth, that was deemed to be ineligible for expungement by some judges in Maryland. So eliminating sort of absurd outcomes like that is the goal of switching to all misdemeanors except potentially a few. If some particularly egregious crimes that for some reason were misdemeanors instead of felonies really needed to be accepted. And then we could enumerate more felonies into the list. So there's a number of drug-related offenses that have been included, but there are still more that could be added. So things like drug distribution felonies that are not crimes of violence could be added to give people a second chance in life, and all sorts of other nonviolent acts after a person, of course, again, has served their time. There's also a number of kind of outlier offenses that are violations, like administrative violations or like municipal county codes and things like that, Department of Natural Resources violations. I was present at a legislative hearing on expungement earlier this year, where a senator actually spoke of a constituent who had a criminal record for a fishing violation, sort of essentially catching too many fish, that more than the license allowed, and this became part of a criminal record. And this person was not allowed to attend his son's field trip at school because the school had a policy that no one with a criminal record could be near the children, which of course sounds perfectly reasonable until you look at the reality of people's lives and people living with criminal records for minor nonviolent violations that they're not allowed to expunge. So the last slide was things that have been more or less already proposed in the legislative halls, but have not yet come around to being passed. There are also more things that we could do, and this slide is really kind of a discussion of how else can expungement access and decriminalization of poverty be expanded. I was talking earlier about the subsequent conviction rule and the way traffic violations work. So things like the suspended license, driving without a license, driving with a revoked license, etc. Suspended license was recently added, but there are no other traffic violations to speak of in the eligibility requirements. One way of getting around these absurd outcomes where a person is convicted of a minor traffic offense and that permanently blocks a serious charge that would otherwise be eligible would be to simply remove any and all traffic violations from the subsequent conviction rule. So create an exception to the subsequent conviction rule that says no traffic non-moving violations will apply as a subsequent conviction, will not count as a subsequent conviction. If you think about what a non-moving violation, that really mostly has to do with keeping up with your kind of payments for the MVA. Someone, say, getting a traffic fine, not being able to afford to pay it, getting their license eventually revoked. Again, this catch-22 scenario where a person needs to pay back these fines, and you pay back things by going to work and earning money, and you get to work by driving your car to work. If you're not allowed to drive, then you're not able to earn the money to pay back the MVA, who's in charge of whether or not you're allowed to drive. So this creates a terrible cycle of people living in poverty, where they are now criminalized for trying to get to work in order to pay back those fines. And then they're hit with more fines, and then they are hit with potentially permanent criminal record, preventing them from working in the first place. I think it's not unreasonable to say that these sorts of violations that have nothing to do with someone's actual driving behavior and more to do with whether or not they have paid their debts, these are not matters of public safety. These do not endanger other drivers on the road. These are the criminalization of poverty in many situations, and they should not count as subsequent convictions for the purposes of criminal record expungement. There is also the discussion around partial expungement. Under the way the current statute works, you can never expunge an individual charge out of a case. So let's give an example. Let's say someone was charged with armed robbery, and then they were charged with driving, let's say, drug possession. They are acquitted of armed robbery and they are convicted of drug possession. The armed robbery is going to be part of that case permanently until it gets expunged. If you were to change the drug possession case to something that's ineligible, like let's say the malicious destruction of property. If we change the example to 2 charges in one case, armed robbery, malicious destruction of property. Not guilty on armed robbery, guilty on malicious destruction of property. Now that person is living with a permanent criminal record that says they were charged with armed robbery. And if they go up to an employer who sees the words armed robbery on their record, that is, of course, going to look very bad. This person is never allowed to expunge the armed robbery charge from their record, despite the fact that they were found in a court of law legally to have not committed that crime. That will be part of their permanent record, so to speak. So there is discussion around what we call partial expungement or elimination of what is known as the unit rule, which says that you can only expunge a total case and not an individual charge. There's also this issue of the way assault works in Maryland. Some states have first, second, and third degree assault. Maryland has first degree assault and second degree assault. First degree assault is generally something that involves a weapon or deadly force of some kind, or serious bodily harm. Second degree assault is in Maryland an extremely wide window of potential acts that could be considered second-degree assault. I have met with many people who have a second-degree assault charge on their record, and in many cases, it is often the result of a domestic dispute where the police were called, maybe even by a neighbor, and two people at a house were fighting, arguing. Maybe someone raises their fists at another person. Oftentimes, both parties in the argument will get charged with second-degree assault. You don't have to cause someone else an injury or necessarily even physically hit them to be convicted of this crime. And this is something that, if convicted, has a 15-year waiting period. And it is a misdemeanor. It's one of the exceptions to the misdemeanor 10-year waiting period, where it's a 15-year waiting period. So now this person has something on their record that even looks to be a violent act to a potential employer looking at their criminal background for 15 years. And oftentimes people don't serve any time at all for this sort of offense. Having a third-degree assault, some people have argued, would allow for this second-degree assault window to close. In other words, the variety of potential acts that could be considered second-degree assault would become much smaller, and a third-degree assault would cover minor incidents, such as sort of common domestic arguments, or just common everyday, the unfortunate reality of life that people argue and get in fights. Instead of having someone be labeled a criminal for 15 years or even the rest of their life, depending on how the subsequent conviction rule plays out. A third-degree assault would allow for, ideally, a much sooner expungement of a minor offense. And then thinking even bigger picture, there is an issue of third-party databases that collect public documents and store them potentially forever in their own private databases. So there's a discussion to be had around what happens when a court grants and orders an expungement. Right now, an expungement order, when granted by a judge, is served on the record-keeping agencies of the state of Maryland. So it's served on the state's attorney's office. It's served on the police department. It's served on the court itself, the clerk of the court, and criminal justice information system databases that have record of Maryland criminal cases. This, of course, makes sense. These are the state record-keeping agencies that have this data that says this case happened and exists, and they're being told by a judge to expunge those records. That's, of course, the entire point of expungement. But when a private company has performed data scraping on the internet to obtain publicly available documentation, and then offers a service, usually to employers and landlords, to run background checks and produce these court documents, can a court make that private company expunge their records? This is an interesting legal question that is maybe on the horizon for the expungement advocacy movement, because it's not something that I have seen happen terribly often, but say someone gets their expungement, say they are under the belief that they have a perfectly clean criminal record because of expungement being granted. and they go to apply for a job, and this employer uses a third-party database to pay for a service that provides background checks. And this database has already stored the criminal case before the expungement happened. So now they have it, even though it's been expunged since they collected it, and it's showing up. And now this person is legally allowed to say on a job application that no, they do not have a criminal record, that no, they've not been convicted of anything, and now it's coming up. And it's looking like that person's lying, and it's looking like they're hiding something, even though they have done everything they were supposed to do and legally obtained expungement. This is putting someone obviously in a very difficult situation, and there's an interesting legal question as to what could be done, what would even be, constitutional or legal otherwise, that would allow Maryland courts to actually force private companies to delete information that has been expunged from the public record. And then there's also automatic expungement. A couple years ago, there was a huge victory for expungement advocates in that automatic expungement was actually passed and has technically, in a sense, gone into effect already. But it only allows the automatic expungement of cases that happen in the future. It does not retroactively go back to automatically expunge any eligible cases that have been sitting around for years or even decades. So there's also advocacy around moving that window of eligibility for automatic expungement back at least a few years, if not back further and further. So someone who was convicted of something in to correct myself, automatic expungement doesn't apply to convictions, but it applies to non-convictions. So someone has 3-4 charges that get null-prossed in 2019. That doesn't count toward automatic expungement. Anything that happened before the law went into effect is not going to go for automatic expungement. So there's advocacy around what can be done to have the courts go back and just start cleaning up these non-convictions. Like I said, there's thousands and thousands of cases sitting around on the books that are eligible immediately for expungement. And again, these are instances where someone was not found guilty of any crime. And, can there be laws that just make the courts go and clean those up and put those away from public view so that someone can not have that held against them? To wrap things up here, the major point behind all of this and the advocacy around making expungement even more accessible is that the consequences of living with a criminal record, even after you have completed your court-mandated criminal sentence, can continue to punish someone for years, even decades, after they've already served their time. Having people denied access to employment and housing has an immense societal cost to not just that person and not just the psychological impact of that person, but to society at large. The fewer people in our communities who have financial stability, the fewer people in our communities who have housing stability, the less stable our communities are overall. So allowing people to re-enter the workforce, to move on with their lives, to remove the stigma of living with a criminal record, remove the stigma of being called a criminal for something that may have happened decades ago. This helps everyone. in our community. And if we want less crime in our community, then we should want more people to have the ability to seek stable employment, stable housing, childcare, and everything else that comes with the benefits of living in the communities that we want to see thrive. So thank you very much for listening to the presentation. I hope this sparked some interesting thoughts about what expungement could potentially look like. And again, a lot of improvements have been made due to advocates fighting very hard in Annapolis, but there is a long way to go. If you are an attorney watching this presentation and you are interested in how you can get involved with helping people expunge their records, go to mvlslaw.org. If you're not already signed up to be a volunteer, you can sign up. You can get access to all kinds of trainings like this one and mentorship. And if you're already a volunteer, you can go check out the pro bono portal at that website, where you can see a list of all the clients who are waiting to have an attorney get on their case and help them with not just expungements, but all sorts of civil legal matters. So again, thank you very much for watching, and check out mvlslaw.org to learn more about what we do.